Good evening, everybody, and welcome to Courtroom Insider. I'm Nate Eaton, coming to you live from Park City, Utah. Let's see, it's 7:01 on Tuesday, May the 12th. Hope you have had a good day. Thanks for being here tonight. We have a lot to discuss, including a explosive document, you could say, that the prosecution in the Kouri Richins trial filed in the case. It's 15 pages. We're going to go through it all tonight and talk about it. Tomorrow, by the way, as you can see, I'm in my hotel room in Park City. We'd love to know where you are tonight and what you're doing, what you're up to, and if you have any questions, because here in just a couple of minutes, we're going to answer as many questions as we can. Peggy Jepson, our comment moderator, is with us, and it's good to be back with you live in a hotel room, I guess you could say. Here's what we're talking about tonight. Again, what to expect at Kouri Richins' sentencing. It's going to be happening tomorrow. 24 hours from now, we will know just what her sentence is. And we will talk about that, plus Special Prosecutor Rachel Smith. You know her from the Daybell trial. She's prosecuted hundreds of cases across the country. She's death penalty certified. She's done hundreds of death penalty cases, murder cases. She is no stranger to those types of cases. She will be here to talk about sentencing, about what we can expect tomorrow from the prosecution, from the defense. Will Kouri Richins speak? What type of victims will speak? All of that. We'll break it all down tonight. So before we get to that, why don't we go back 2 months to when we were sitting at the Summit County Courthouse waiting for a verdict. You might recall the jury was given the case. The judge sent them back to deliberate. It happened late in the afternoon, I think around 3 o'clock. And we were all wondering when the verdict would come back and what the verdict would be. We were at the courthouse. I remember I was in the media room off adjacent to the courtroom when someone came out and said, there's a verdict. And it was like 6 o'clock at night. So it'd been 3 hours. It wasn't long, which isn't good news for a defense attorney. You want them to go long and days and days and days. That didn't happen in this case. In fact, they came back after 3 hours, and they had to contact the defense. They had to contact the prosecution, Eric Richins' family. They had to do all of that. In fact, Eric's dad, I believe, was having dinner, and we were all in the courtroom waiting for him. No fault to him. I mean, that's just what people were doing at 6 o'clock in the evening. So he's eating dinner. He comes to the courtroom. Kouri Richins, I'll never forget, was shaking in front of me. I was seated behind her. She was in a white flowered blouse, shaking, and her defense attorneys, one of the, Alex Ramos, had a rosary, I believe, that he was praying over, and nothing was on the table. It was so different from what we see at trial every day with laptops and notepads and notebooks and all that. And the table was empty, and it was silence, just completely silent. Nothing really happening at the prosecutor's table. And then the judge came in, and, well, actually, why don't I just play it? This was the moment Kouri Richins learned she was guilty.
Folks, please have a seat as you come in. Please have a seat. Ladies and gentlemen, would the foreperson you've selected please stand? May I ask you a yes or no question? Has the jury reached a unanimous verdict?
Yes, we have.
Would you please hand the verdict form to the deputy, and you can have a seat. Thank you. I'll take that. All right. Counsel, Ms. Richins, please stand. Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of aggravated murder. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count 1 beyond a reasonable doubt. The homicide was committed for pecuniary gain. and the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Count 2, attempted aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of attempted aggravated murder. We, the jury, unanimously agree the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt. The attempted homicide was committed for pecuniary gain. Count 3, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 4, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 5, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery. It's signed by the foreperson. Please have a seat. Madam Foreperson, is this the verdict that the jury reached unanimously?
Yes, it is.
Okay, you may have a seat. Ms. Lewis, Ms. Nestor, do you wish the jury to be polled?
Yes, please.
All right. Folks, I'll ask you the same yes or no question, one at a time, starting on my left, working this way. Front row first. If you could show me your lanyard number as I ask you. Juror number 5, is this the verdict you voted in favor of?
Yes.
Juror number 4, is this the verdict you voted in favor of? Juror number 3.
Yes.
I can't see your number, I'm so sorry. The foreperson, I just need to ask you again, I'm sorry. Juror number 2.
Yes, it is.
Juror number 1.
Yes, Your Honor.
Sir. Juror number 8.
Yes.
Juror number 7.
Yes.
Juror number 6.
Yes.
All right. Count.
Okay, that was the verdict day. Now, shortly thereafter, the judge, within minutes, asked if they said there was a couple of days where Kouri Richins could be sentenced, and they decided on May 13th, which is tomorrow, which is Eric Richins' 44th birthday. And at the time, the judge didn't mention anything about his birthday. No one did in the courtroom. But if you go back and watch the tape or the video of when they were discussing the sentencing, you can see when the judge says that date that Eric's sisters kind of smile, like they know that it's his birthday. Well, we've since learned that with the very next day, Kouri was talking to a family member on the phone, and they said, are you really going to get sentenced on Eric's birthday? And Kouri apparently said, well, I've talked to Kathy Nestor and I've told her to move it off to the later part of May, and she says she will do that. We learned that because the defense filed a motion asking the sentence be postponed until June, the week of June 15th. For 4 reasons. They said, 1, that Kathy Nestor, one of her attorneys, had a death in the family. 2, Alex Ramos, another attorney, had another trial happening this week. 3, they needed more time to prepare witnesses. And 4, they needed more time to prepare mitigation for the sentencing hearing tomorrow. Prosecution immediately was like, no. She's got 3 attorneys. If you can't figure it out with the 3 of you, I'm obviously summarizing, then, 1 can do it, whatever. 2, the family has held on long enough, Eric Richins' family, that Kouri Richins can no longer determine what's happening with this thing. And then the judge decided, another reason they wanted it is they said that the judge had only set aside tomorrow morning, and that the defense said they likely need more time. So the judge responded, denied the request, and said, again, Kouri Richins has had 3 skilled attorneys that can do this thing. If Kathy Nestor had a death in the family, you've got Wendy Lewis. Same with Mr. Ramos's trial. They could figure it out. Also said that the rights of the victims need to be weighed here. And he said, whatever the prosecution wrote in their document that was redacted, part of it was blacked out to the public, dealing with juveniles, likely Eric's kids, was compelling for the judge to say those kids or whatever was in the redacted portion of the motion, that had an effect on the judge to say, we're not going to delay this sentencing. And he said, my calendar is cleared tomorrow. So if it goes past lunchtime, the judge is fine with that. So judge ruled on that last week or the week before. And then yesterday, I should say, the prosecution filed a sentencing memorandum. Now, I got to be honest with you. I have not seen this before. Some prosecutors do this. Some don't. Many don't. Like in Vallow and Daybell, they didn't do a memorandum or anything like this. But the prosecutor did, Brad Bloodworth. And I read it this morning and wow. In fact, I want to read it with you so you can see exactly what the prosecutions are arguing and you can kind of get a preview as what we can expect tomorrow. So why don't I pull up this screen here? You should be able to see it unless you're watching on a phone. If that's the case, you'll get to hear from me. So this is written to Judge Richard Mrazek from Brad Bloodworth, the chief prosecutor for the case. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, what have I done? Rather, she thought, how can I do better? And then she murdered Eric in the presence of their children, using poison and for money. Such a person should never again lurk among the rest of us. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Kouri Richins has earned it. Her children deserve it. Only this court can order it. Pause right there. That's a pretty powerful paragraph. There are 2 options Judge Mrazek will consider tomorrow. One is 25 years to life in prison, meaning she goes to a minimum of 25, and at 25 years, the parole board in the state of Utah, she will go before them and argue that she should be released. And then the parole board will make a decision, not the judge. And they could say, no, you need 7 more years or you need 10 more years, and then she'll go back. Or the other option is life, no parole. She goes away, it's done. The prosecutor will argue that, which he clearly does. Back to the document. State's sentencing request, count 1, aggravated murder. The court should order the defendant to serve life in prison without parole. Count 2, attempted aggravated murder. The court should order the defendant to serve 5 years to life in prison consecutive to any other sentence. Consecutive means after. Concurrent means running at the same time. So they're saying aggravated murder, life, no parole. The attempted murder for the Valentine's Day incident, 5 years to life, but consecutive. Obviously, you can't serve a time after your life, but for the purposes of the court documents, that's what they're saying. Count 3, insurance fraud, 15 years in prison, consecutive. Sorry, 1 to 15. Same with count 4, and same on the forgery, it's 1 to 5 years consecutive. Point 6, the court should enter a continuous protective order in favor of Eric Richins' family members that prohibits the defendant from contacting them unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of CR, AR, and WR. Eric Richins' family members include CR, AR, and WR, his children, Jean Richins, Katie Richins Benson, Clint Benson, MB and LB, children. That's why they're going by initials, and I won't say their names tonight. And Amy Richins and Andrew Swenson. The court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1,017,018.49 and True Stage Insurance Company in the amount of $352,562.61. I know you're saying, how is she going to pay that back? Well, they're asking the court to order her to. Then we have, oh, my screen froze for a moment. Okay, stand by. I don't know if that's freezing on your end. Let me try this thing here. Okay, hopefully you didn't lose me. Am I still here? There we go. Let me just make this bigger. You know that I have the tech issues every time I'm in a hotel. But let's pray that doesn't happen tonight. Okay. That's happening. And Jordan, by the way, Photog Jordan, he's here. Okay, there we go. Let me make this bigger so you can see it. Okay, I don't know if you can see that. Just one moment. I'm gonna continue reading this. The court should order the defendant to pay Summit County in the amount of $1.3 million. So they're asking for restitution, and they're asking for her to pay it back. Now, in some cases, while I load up the document again here so I can continue reading it, in some states, like in the Lori Vallow case and Chad Daybell, they were ordered to pay the victims first before they pay the fees, the fines. So often the judge will order restitution for the victims, and that normally is the first priority, followed by fines, fees, things like that, and that could be the second priority. Clearly, the money here, she's never going to be able to make the $1 million in prison, and we know that she had the $8 million in debt that she owes to outstanding lenders. She's got the civil lawsuit. She's got all sorts of financial issues. But I guess should she inherit a ton of money from somebody who dies, or should she, come upon some money and she suddenly has it? Then it appears that the prosecution is saying first she needs to be able to pay the family before she pays Summit County back for all of the fines or all of the fees that they took prosecuting this. I would imagine when this all comes out that there's going to be a total cost for this investigation into the millions. Lori Vallow's Idaho one was 3.8, and I think that was before they even went to trial. So these are quite expensive. Okay, I think I have my screen back. Here we go. So, argument. This is what the prosecution is arguing. Ooh, here we go. When sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapitation, restitution, and rehabilitation. For consecutive versus concurrent sentencing decisions, the court must consider the gravity and circumstances of the offense, the number of victims, and the history, character, and rehabilitation needs of the defendants. A sentence in a criminal case should be appropriate for the defendant in light of his background and the crime committed, and also serve the interests of society which underlie the criminal justice system. The court is to examine both aggravating and mitigating factors, to include the nature and circumstances of the crime, the defendant's character, background, history, mental and physical condition, the impact of the crime on the victim's family and community, and any other facts in aggravation or mitigation of the penalty. Not all aggravating and mitigating factors are equally important, and one factor in mitigation or aggravation may weigh more than several factors on the opposite scale. A few egregious aggravating factors may outweigh several mitigating circumstances claimed by the defendant. So they are saying here that that you could have all sorts of, aggravating factors that that are bad, basically, but those and just 2 or 3 of those could outweigh all of the good stuff that they might say about her. Okay, so continuing. The psychological reality is that aggravating circumstances in first-degree murder cases will virtually always outweigh or be more compelling than the mitigating circumstances because the commission of a capital homicide, i.e., an intentional murder, is one of the most heinous acts known to society. The emotional impact of all the evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of the sentencing authority. So, if you got that, basically they're saying this is the worst of the worst. You can't get it any worse than this. And because of that, the judge should give her life. The court, whoops, wrong button. The court is to consider the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. The court is not to limit it to the circumstances of the crime for which the defendant has been convicted, but may consider other factors as well. Evidence that is admissible at the guilt stage may be admissible for the purpose of sentencing. Such information must be reasonably reliable and relevant. Hence, the state took the death penalty off the table in the early days of this case. Many of you have asked about that. Is it death? Accordingly, on count one, the court must sentence the defendant to either life without parole or the indeterminate term of imprisonment for 25 years to life. There's no presumption in favor of either of the two sentencing options. In total, the egregious aggravators outweigh the perfunctory mitigators and require a sentence of life without parole. Okay, so you got all that? That's a lot of legal stuff. Now we're getting into the fact of, or the facts that the prosecutor says just how bad these crimes were. So, oh, there I am. Here we go. Let me enter full screen. Which, by the way, in a minute, we're going to have Rachel Smith here, and she's going to talk about why the prosecutor may have filed this. It's not like, well, maybe we can expect the prosecutor tomorrow to go on and read all of these things during the sentencing, read this whole 15-page document. I don't know if he will. Just one second. Of course, the update that wants to happen to my computer is happening right now. And what I'm going to do is reset it so that I can be there. I apologize for this. Here we go. Cancel. I should play some hold music. By the way, I'm curious to know, let me just reboot this in this other program, what you think the sentence will be. And did the prosecution, present a compelling enough case during the actual trial to ask the judge to do life without parole? And that's what the argument could be tomorrow for them. I know a lot of you are saying, absolutely they did. There's no question there. But could the defense come out with the fact that her children need her, even though you'll hear in a moment that her children, it sounds like, don't really want anything to do with her. And in fact, they're scared of her. Could the defense come out and argue that she had a rough childhood and that things were rough for her at home? Interestingly, as of 10 minutes ago, before I came on here, or 20 minutes ago, the defense had not filed a sentencing memorandum. I was looking for it and thinking they might file one. They could do it tomorrow morning, right before the sentencing, or maybe they have it ready and then they file it after the sentencing. But I was expecting for them to respond, and they have not. So we'll see. We'll see what they have to say. Okay, back to the document. I think I have it here. There we go. Argument. We talked about that. Okay, now we are into the part of, okay, when sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapitation, restitution, and rehabilitation. I think I already read this one. Yeah, I did. Sorry. Here we go. Yep. Okay. 1, the court should sentence the defendant to life without parole on count 1. The defendant murdered her husband in the presence of their young children using a poison for money, and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous as to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The defendant chose poison. I'll make this bigger so you can read it. Jurists throughout time have recognized that particularly heinous nature of homicidal poisoning. Of all the species of death, the most detestable is that of poison, because it can, of all others, be the least prevented either by manhood or forethought. The Florida Supreme Court has called poisoning a conscienceless, pitiless crime. The California Supreme Court observed a murder carried out by deliberately giving the victim poison is more cruel and aggravated than other malicious or intentional killings, both because such a killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance. The poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust. Here, the defendant betrayed the most intimate trust of her husband and her children. The defendant decided that Eric Richins' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. In one such case, the Arizona Supreme Court observed the killing in this case did not arise out of a heat of passion, fear, struggle, or attempt to escape. The killing was not just the result of momentary premeditation, but of defendant's deliberate, carefully conceived, meticulously planned, and cold-blooded scheme to kill, rather than divorce his unsuspecting wife. And that they're talking about another case. But the prosecutor here is citing that as precedent. Then the New Jersey Superior Court observed these killings do not stem from some powerful visceral emotion, but rather from greed and expedience. Furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all the rules that society has constructed to maintain communal life and warrants the fullest condemnation and retribution. This is quite hard to read, the next few sections. Fathers are not meant to bury sons, and losing a sibling is losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. The aggravated murder crime was a crime of domestic violence in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew that the defendant tried to murder him on Valentine's Day, and he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they know it. CR was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. Following Eric's death, DCFS supported a finding of emotional and physical abuse by defendant against CR. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. CR wants the court to know that, quote, my dad was a good person and very thoughtful and kind and helped whoever needed help. And that, quote, I'm afraid if she gets out, she will come after me and my brothers and my whole family. I think she would come and take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri, I will tell you that. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. If called to testify at trial, AR would have recalled being put to bed early on March. This is new, by the way. We haven't heard this before. AR would have recalled being put to bed early on March 3rd without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom. And when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. Later, during the night, his younger brother, WR, woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father. AR wants the court to know that, quote, my dad can't be my coach anymore and can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. And that, quote, I don't want the defendant out of jail because I will not feel safe if she is out. With her in jail, I will be able to continue to feel safe and live a happy and successful life without fear of her hurting me or anyone I love. WR was still in preschool when his mother murdered his father. He has now lived half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in the bedroom before his Aunt Katie arrived. WR wants the court to know that, quote, when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad, and that if she got out, I would be so scared. I'd worried that she would take me away. Once she is gone, I will feel happy, and I will feel safer and relaxed and trust more people. That is heart-wrenching. I've got 2 little boys and a daughter, and my sons have tried to get into our room every night for the past 7 years. You know how it is if you have kids. We're like, go away, go away. You can't come in here. And every night, sometimes they end up on the floor. We never know. It's musical beds at our house. We never know where anyone's going to be when we wake up in the morning. But my 2 sons, the one climbs in bed with his brother pretty much every night or 90% of the time. I cannot imagine these kids that night that their dad is dying, being killed by their mother, and they're scared. And the one can't leave the room and he wets his pants because he's scared until his aunt comes. I mean, this is awful. And I don't think the boys will be there tomorrow. I'm pretty sure of that. I don't think they don't want the kids to see their mom. And I just can't imagine what they're going through. If the defendant, continuing on here, if the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 35, 35, and 30 and likely have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous trauma and upheaval the defendant inflicted upon their childhood, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys and everyone is thriving, but Katie and Clint never planned for it. Katie never planned to administer an estate and a trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder's impact extends beyond Eric Richins' family. Josh Grossman, the boyfriend, bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. It has gutted him. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Ms. Barney's life savings. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drugs. Cody Wright and Josh Kays question whether they could have done more to save their friend. Point letter C. The defendant's character is irredeemable. By the way, if you're just tuning in, we're going through a document filed by the prosecution, Brad Bloodworth. It's a sentencing memorandum that he wrote to the judge before Kouri Richins is sentenced tomorrow. And this is a breakdown of why they are asking for life in prison without the possibility of parole. She'll either get life or she'll get 25 years to life. And they're going through bullet point by bullet point why they argued that. Okay, so with there, we are on to the defendant's character is irredeemable, as is my computer. But it can be redeemed, I think, here. We're more than halfway through here. Let me just go into this other program. I apologize for that. And then we'll talk about what will happen tomorrow at the sentencing, which, by the way, it begins at 9:30 Mountain Time. We'll start our stream around 8:45 on East Idaho News, on wherever you're watching right now. You can watch it, or our Courtroom Insider YouTube channel. If you haven't subscribed to that, we have a brand new YouTube channel. It's at courtroom.insider. You can go there and watch trials there. So it's going to start at 9:30, and we'll likely, I don't have a list of who's talking or whatnot. I do know a few people who are going to be speaking, but I won't repeat that here, but it's likely that we'll hear from his sisters, from Eric's sisters, probably his father, Eugene. We'll hear likely from others that are close. And then the defense, from what I understand, could call some mitigating witnesses who will basically argue that Kouri should get 25 years to life, and Kouri could very well give a statement too. And it could go for 3 hours, it could go for 2 hours, it could go for 6 hours. There's been sentencings that have been 2 days. And I don't think this one will go 2 days, but the judge has cleared his calendar for that. Okay, back to the document. The defendant's character is irredeemable. Let me make this bigger. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing from her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt quote-unquote judge, and unfair Summit County jurors. 6 weeks following the guilty verdict, the defendant text messaged an admirer. This is new too. I will, in all caps, expose this county, the prosecution, the judge, the Richins, the investigation, all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come back. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I'm going to expose them all for what they have done to me, my kids, my family, this injustice. They picked the wrong one. They think sentencing is the end, closure. It's just the beginning. They haven't seen anything yet. Winky emoji. Most telling of her character, the defendant attacked Eric. Within hours of her arrest, she, for the first time, blamed Eric for his own death. From jail, the defendant and her family engaged in open season on, quote, Eric the Dead, releasing what they believed to be damaging information about Eric to the media. During trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richins children are familiar with the inescapable media coverage of this case. Many of the defendants, media coverage of this case. Many of the defendants' attacks against the Richins family permeate the record. For example, she throat punched Amy Richins 2 days after murdering Eric when Amy informed her of Eric Richins' living trust. Eric created the trust to protect her and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richins that Eric died of the same lung mold that killed Jean's wife. Cruel. In the Walk the Dog letter, the defendant instructed her mother to release photographs of Casey's young children to the media and wrote, "Bring me home and then we'll get those damn bitches," referring to Eric's sisters. When confronted with the letter, the defendant insisted in the face of all reason that it was part of, quote, a freaking book, a half-true, half-fiction novel about her incarceration. Other of the defendant's attacks against the Richins family are new to the record. This is new. For example, when the estate's investigator found bank statements with Kouri Richins' realty accounts header and C&E's accounts data, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pre-trial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping, filed false reports with DCFS against Katie, and report Amy Richins to the police for marijuana possession. To this day, the defendant maintains insurance policies on the lives of her children. The Richins family will not be safe if the defendant is ever paroled. The defendant attacks extended beyond the Richins. While detained pre-trial, the defendant caused her family members to file unfounded bar complaints against the Summit County attorney and chief prosecutor and post a, quote, a gay dating profile of the lead detective online. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner. The defendant's character is evident despite her well-crafted facade. Okay, I got to pull up page 2. This is, what do you think? I'm interested what you think of this so far, of this new stuff that we're learning that is quite astounding, and I imagine the judge will take this into account. And now I think I know why they filed this. Why, I was wondering earlier why they would file this, but I think I know now. I mean, this is a lot. The defendant's character is evident despite her well-crafted facade. Eric's surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. The irrational nature and circumstances of the aggravated murder, an irreparable impact on Eric Richins' family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defendant presents will only be more facade. It is all she has. But even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment, short of death, and public safety requires her permanent incapacitation. She is well established that rehabilitation is beneath her. Life without parole, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be poisoners from coldly murdering their spouse and their children's parent. Then point 2, the court should sentence consecutively as to the remaining counts. The gravity of the attempted aggravated murder is that the defendants learned from her mistakes. She learned to obtain something stronger and to administer in a way that prevented Eric from realizing the poison's effects until it was too late. The circumstances of the attempted aggravated murder are identical to the circumstances of the murder. The gravity and circumstances of the fraud and forgery punch above the charge's weight because they encompass the defendant's motive for murdering Eric and the gain aggravator. The defendant's character, as discussed, is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 through 5, and the court should sentence them consecutive to any other sentence. And then 3, about the protective order in favor of Eric's family members. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's criminal protective order statute provides that when a perpetrator is convicted of a domestic violence resulting in the sentence of imprisonment, that is to be served after conviction. The court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victim unless the court determines by clear and convincing evidence that the victim does not have a reasonable fear of the future harm or abuse. The protection may include any order the court considers necessary to fully protect the victim and members of the victim's family. Here, Eric Richins is the only victim under Utah's crime victim statute. Paradoxically, Eric Richins' family members, including his children, are not, quote, victims. It is evident that Eric Richins does not have a reasonable fear of future harm or abuse, which the criminal protective order statute thresholds applies, inquiry. Thus, the criminal protective order statute yields the absurd result that family members of a domestic violence murder victim are left unprotected when family members of all other domestic violence crimes can be protected. Sounds like there could be a law passed here concerning this, that basically family members of domestic violence victims in other types of crimes are protected, but when it comes to murder, the surviving family members are not in the state of Utah. This is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that no rational legislator could have intended the statute to operate in such a manner. This standard is satisfied only if the legislature could not reasonably have intended the result. This standard is satisfied here. Clearly, the legislature could not have reasonably intended to accept the family members of domestic violence murder victims from protection. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. Accordingly, the court should issue a continuous protective order under Utah code that prohibits the defendant from contacting Eric Richins' family members unless they first initiate contact and prohibits her from maintaining or benefiting from insurance on the lives of CR, AR, and WR. Finally, the court should order the defendant to pay restitution. Utah Crimes Victim Restitution Act requires district courts to determine restitution for any pecuniary damages approximately caused by defendant's criminal conduct. Insurance companies are victims under the statutory definition. Additionally, the defendant is a killer within the meaning of Utah's so-called Slayer statute, which provides that a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that a killer cannot profit from the killer's wrong. The defendant received over $1 million from Auto Owners Insurance Company and $352,000 from True Stage Insurance Company as the beneficiary of Eric's insurance, life insurance. These insurance companies paid out as a result of the defendant committing aggravated murder as a convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 through 5. Accordingly, the court should order the defendant to pay restitution. Final point 5. After Ray, Quinney, and Nebaker abruptly withdrew from this case in May of 2024, the court declined to require the defendant to complete an affidavit of indigency. I can't say that word, citing Fifth Amendment concerns. Those were her attorneys. The court found that the defendant was indigent on the sole basis of former counsel's representation that the defendant does not have access to financial resources sufficient to retain private counsel, emphasis added. Summit County thus became statutorily obligated to provide defense services to the defendant. The cost of these services will exceed $1.3 million for the defense. If the court learns that an individual provided with indigent defense services is in fact not indigent, the court shall order that individual to pay the indigent defense system the cost of services. The defendant continues to litigate claims to Eric's premarital home and a share of the trust. To the extent any of these assets or any other assets are adjudicated to the defendant's property, the court must order $1.3 million of those assets paid to Summit County as recoupment for the indigent defense services. Additionally, the court may order a defendant to pay costs for expenses incurred by a political subdivision of the state for attorney fees of counsel assigned to represent the defendant. To the extent that the defendant or her representatives or assignees receive any money that is not the subject to the profit from Notorious Criminal Activity Act, the court should order $1.3 million to be paid to Summit County for indigent defense services. And now the conclusion. Thank you for bearing with me. The court should sentence the defendant to life without parole among the state's other sentencing requests. This sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richins' family, and her irredeemable character. This sentence serves the interests of society which underlie the criminal justice system. Most importantly, no other sentence can provide CR, AR, and WR the comfort and protection that they need and deserve. That is the sentencing memorandum filed yesterday by Brad Bloodworth of the Summit County Prosecuting Attorney's Office. As I mentioned, we don't have one from the defense. We don't know if they'll file one. They very well could right before tomorrow happens. But what a document that is. So that kind of gives you a preview, I guess, of what we'll hear tomorrow. Now, just before we came on here, I Zoomed with Rachel Smith. Again, she's the special prosecutor, not connected to this case. I want to be clear. She has nothing to do with this case, but she's done several similar cases of spousal murders. And I wanted to get her take kind of on what we can expect tomorrow and what to watch out for and a couple of other things. So let me toss over to that interview now with Rachel Smith. Appreciate your insight. So night before sentencing, what do you think the prosecution and the defense are preparing for tonight?
Thanks for having me, Nate. The night before sentencing, they are focusing on a couple of different things. They focus on making sure they present persuasive arguments to the court on the areas they think the court will want to hear. They also focus on making sure that the victims and their family get their day in court, and that information that might not otherwise come out is put in either a sentencing memo or put into their oral argument. So it's dotting your I's, crossing your T's, and planning the best arguments in front of the judge.
And we know that the prosecution already filed their sentencing memorandum, what they're going to argue for life with no parole. The defense obviously is going to argue 25 to life because those are our only two options based on the convictions. Um, I mean, it seems kind of straightforward with those two options, but is this one of those that the defense is going to go all out and they could call witnesses and mitigation and really try to persuade the judge to go that way?
It is one of those cases they could, and in some respects they should. What it does is it builds an appellate record, trying to establish that the court perhaps had a sentence that was disproportionate or excessive given her background. So I would expect to see some witnesses. I would expect to see witnesses that are really focused on sort of what sort of person she was, what sort of mother she was, any mental health issues or trauma she might have suffered. They will focus very much on the things that would get the judge to feel sympathetic, or that would show on the record that perhaps the verdict or the sentence is excessive.
Mm-hmm. And meanwhile, the prosecution we know is going to go, no, life is the only option.
Yes, the prosecutors in this particular case, given that somebody who was taken, the loss of a parent to the child, given the spousal betrayal, the prosecution is going to really focus on this isn't a person that has true success or true ability to reform or redeem. So it's kind of a contest between the defense trying to frame her as somebody who is a victim or capable of redemption and rehabilitation, and then the prosecution showing who was taken, how they were taken, who suffered a loss, and how her conduct really indicates that she is not capable of rehabilitation.
I've covered many other trials, and I don't recall seeing the prosecution filing a sentencing memorandum the day before sentencing. Why do you think they did that? There might be a legal reason. Maybe in Utah they have to. I'm unaware of that. But is that just to really get it in writing? And is that something you think we'll see them read from tomorrow, or just reference, or why do you think that is?
Prosecutors typically do a sentencing memo for a couple of different reasons. They want to highlight in detail things that they would expect the court to consider that there may not be an opportunity to present in court, in terms of witnesses or impact statements from people who don't want to speak. So the sentencing memorandum allows them to put that information in. The second thing is it allows crystal clarity on what they're asking for and why. And so this way they aren't relying on victims' families to hear it right, or journalists to get it right, or the court to understand and hear everything. It's in writing, the reasons what they're asking for, why they're asking for it, supported by evidence. I have often done a sentencing memo, so it's not unusual, but it's usually for victim impact that you're not sure you're going to be able to have heard in the courtroom, and for crystal clarity for the court, the public, and the family.
Yeah. As the prosecution, you work with the victims, I imagine, to prepare victim impact statements because you can't just go in there and say whatever you want.
Right.
How do you decide who can speak? I mean, Eric Richins had friends and colleagues and roommates back in the day. Who gets to take the stand? Is it just family? Is it just up to judge by judge?
It's a couple of different factors. One, it will be defined by statute or constitution of the jurisdiction you're in. Some places have a very narrow definition of who is entitled to give victim impact. It's usually next of kin, legal next of kin, people with close associations. And so they start with the statutory definition of who has the rights, and then they go from there. In the past, I have not truly limited written victim impact statements. The court is presumed to ignore what it can't consider. So there's really no harm in submitting things that are done in writing. And then I stick very clearly to the people who have a legal and statutory right to be there to protect the conviction, to make sure that the defense doesn't argue it was an overreach, So I stick to the statutory people who are entitled legally to speak, and then I submit on the record things in writing from pretty much anybody else.
I see. So tomorrow, the judge could have a stack of victim impact
Mhm.
statements that we don't necessarily hear from, but he can read and consider that. Do you think,
Absolutely, and those are typically given to the defense attorney either morning of or in advance. I give it in advance because there are some courts, appellate courts, that scrutinize victim impact evidence pretty closely. For example, in the state of Hawaii, they're not even allowed to call the victim a victim by court orders. So, whereas in other places like Idaho, you can define who is a victim, but it's a pretty narrow definition. So prosecutors will typically submit in writing things that the court can consider or say, I'm not going to rely on it. But then in the courtroom, you stick to the things that aren't going to cause you issues on appeal.
right? Do you think, this is pure speculation, the judge has already decided the sentence? Or in your experience, does what is being said make a difference the day of?
I do think there are times where judges have been persuaded the day of. Most of the time, I think they have a pretty good idea of what direction they're leaning. But I was on a case a few weeks ago where the verdict was a sort of split compromise verdict. And the court had originally indicated sort of in chambers they were leaning one way. And we stepped out and really encouraged the person's grandmother or mother to speak. And then the ADA who was arguing the sentencing really hammered on a couple of key points. And the judge did not follow what they said in chambers. In fact, gave the state what it was asking for. So I do think there are times judges are persuaded by what happens in the courtroom. They are persuaded by the reminder of who was lost and what society and families lost. So yes, they go into it, I suspect, having judges who are friends and talk to them with an idea, but evidence from either side can persuade them in the moment, and that's where we want it.
The fact that this is so high profile and there's going to be really no public seating because it's going to be family members, friends, and the media. Does that weigh on a judge's mind, do you think, that there'll be perhaps hundreds of thousands, millions watching tomorrow?
It has to, right? They have to be aware of how the judicial system is viewed. They have to be aware of whether the community thinks justice was served. Do I think media pressure makes a decision or public pressure absolutely makes the decision? No. But I think we would be naive to not understand that a judge, of course, understands the significance of what they're doing, both to the families and the parties, but also to the community they serve. Most judges are elected or appointed public officials who serve the community, and they will recognize that they are the voice of the community in that instance. And so they will be aware of what role they play in showing that the justice system works.
Some defendants speak. In fact, many defendants speak. Lori Vallow gave her dissertation. Chad Daybell did not speak. Does having the defendant speak make a difference, do you think?
I personally don't. I've only seen it work a couple of times, but never in a violent, serious crime. In crimes sort of where the person has a substance abuse and is rehabilitated, or where the person has accepted responsibility really deeply and passionately, I've seen that have an impact. But I'll be candid. If I were a defense attorney, I would be really encouraging my client to keep their mouth shut, other than to say, I express true remorse. I am very sorry for the loss of life. And, this trauma has affected so many people, and I regret that. Other than that, they're really better off keeping their mouth shut and focusing on appeal.
Have you ever been in a courtroom where the defendant stands up and is like, I didn't do this, is like defiant that they had nothing to do with it.
Yes, absolutely. And they double down. I mean, in some respects, that's what Lori Vallow did, right?
Right.
She not so overtly, but
Yeah.
she doubled down on why what happened to her was not justice and
Right.
why she didn't do it.
Right. So Kouri Richins is facing a slew of other charges in another case that has yet to go to trial and a civil matter with the Richins family. Let's say she's sentenced to life in prison, no parole tomorrow. Does that, do you think, affect the other case of all the fraud and everything? I mean, we know that Lori Vallow went through it again in Arizona twice. The other charges are still in Utah, same county. So, I mean, do you think the prosecutor could say, all right, she's done her time, or do they bring her back in a year and we do this all again?
I'm a firm believer that you bring her back and do it again. You never know what's going to happen on appeal. You have really solid belief that you did it right. But I have had cases where the courts have changed the jury instruction and decided the instruction was wrong, or that they created a whole new instruction that should have been followed. So I am always about, if you want somebody serving time and having that sort of measure of justice, then you try them for which you charged. Um, so it is possible that they would drop that case, but it is equally possible that they will decide to go ahead and try it as sort of backup and a second measure of accountability.
Yeah, you've mentioned appeals a few times tonight, and I think so many of us forget that. We're focused on
Right.
the here and now, whereas the attorneys have to be focused on the day after when the appeal might be filed, or 3 months from now, and it continues to go forth. Rachel, always a pleasure. Do you have anything that you want to add?
No, it'll be very interesting to see what the court does in this case. I don't think it's much of a contest given the depravity with which she approached her husband's life. I will be shocked. And let's hope I'm not shocked if another verdict comes out, another decision comes out.
Yeah. All right. My thanks to Rachel Smith for chatting with me. She's always great to talk to, and she's traveling all over the country covering these different cases all over the place. Here is what you need to know for tomorrow. The sentencing starts at 9:30 Mountain Time, and that is 8:30 Pacific, 10:30 Central, 11:30 Eastern. So you can log on to this East Idaho News YouTube channel starting at around 8:45. We're going to go live. We'll have a standby graphic up. Peggy will be in the chat. You can chat, and we will go live. And after the sentencing is over, we will go out to the parking lot and we will see if the Richards want to speak. If they don't, that's okay. Totally up to them. Whoever wants to maybe speak to the media, they may have a statement. I have no idea. And we'll provide coverage for you there. And then tomorrow night, I'll be back here, same time, same place, for Courtroom Insider, breaking down the sentencing of whatever happens tomorrow and who we hear from. So hope you can tune in for that. And I have your questions here, but I want to let you know, here's where you can find me. I'll be posting updates tomorrow on my Facebook page, Nate Eaton Reporter. Follow me there. I'm on X. Instagram is more personal type stuff. And then East Idaho News on YouTube. If you haven't subscribed, that would be awesome. Also, our Courtroom Insider YouTube channel that we just launched, I think it has like 40 subscribers. Thank you to those of you that have done that. Peggy is going to post a link in the comments because it can be kind of hard, but it's courtroom.insider to find on YouTube because it's a brand new channel. She's posted that there if you want to click there. We'll still be live here, by the way. We'll still go live, same stuff here and there, but that's just over time. We'll probably have more court coverage on that channel versus East Idaho News. So I just, wherever you are following, thank you. Thank you. Thank you. I appreciate it. Okay. We have some shout outs. We have some questions. Here we go. Peggy Fletcher Boy gave us $19.99 to buy a cake in honor of Eric and eat some. That is very cool. Thank you, Fletcher. I would say to anybody watching tomorrow, if you can take a moment and think about this guy, Eric Richins, who should be turning 44. with his boys and have an incredible cake. And it's the weather here in Summit County and Park City is beautiful, and I can just see spring soccer and baseball and all the summer sports and camping and fun. I mean, this is the time of year to be here. So anybody watching tomorrow, take a moment and think of Eric and him. It is sad that he won't be here. And you know, if I meet him one day in the afterlife, I'll just say, Eric, thanks for giving me an excuse to have cake, because you know I like my sweets. But thank you, Fletcher Boy, for that. Kim Brown, hello to Kim, Risa Greenwood, Shirley Baker, Dustin Smith, Carl Sorensen, who's driving the Uber along the Wasatch Front in Utah. Thank you. I hope you're listening, not watching while you drive the Uber. But if you are watching when you're pulled over, thank you for watching. Jerry Burdick, Joy Moore, Cindy Jacobs, Dustin Smith, thank you all. We have people watching tonight in Costa Rica, San Francisco, Ammon, Idaho, Yuba City, California, Afton, Wyoming, Ocala, Florida, Burley, Idaho, and San Diego. Thank you all so much for being here. Okay, questions. Why did no one address that it was impossible for him to be cold to the touch in 4 hours? He was under covers in a warm room. It wasn't possible he was cold to the touch. Good question there. I don't know why they didn't address it. Maybe it was too much room for questions. I mean, that whole timeline, it makes you wonder now that in this sentencing document, the son says that his mom was never in his room, and the room door was locked, and then he went back to bed in his brother's bed. What really happened that night? She said they had the drink around 9, 10-ish, 8-ish, somewhere in that time, and then he went to bed. I mean, maybe he died hours earlier. You're right, he was cold to the touch, and it says 4 hours. It could have been longer. I don't know. There's a lot of questions. Will there be a victim impact statement? If so, do you know who's on the list, and can you share it? We talked about that briefly. There will be victim impact statements. I don't know who's on the list. I know I've been in cases before where they're finalizing it up until right before, where some victims are like, yeah, I'm going to do it. And then they show up and they're like, no. And some are like, I'm not doing it. And then they get to court and they're like, I'm doing it. I've covered both cases. In fact, there was one case I covered years ago where the woman was so fired up. She showed me her statement, and it was powerful. And she was scheduled to go toward the end, and the other victims went. And when she got up there, she said, I don't think I want to say anything, and sat down. She said enough had been said. So we'll see the order. Let me grab a drink. Are the Richins kids officially adopted? I don't know, to be honest with you. I would doubt it. And I think that one of the reasons, just me speculating, is they're waiting for tomorrow. They're waiting for tomorrow for the sentencing to happen. And maybe legally they can then go to the court and say, listen, their mom's been not only convicted of murder, but she's serving life in prison. We need to officially adopt. So many legal things likely happening, behind the scenes that we don't know about and should be kept private. So I don't know the answer to that question. Is she making money off of her kid's book? No, I don't believe she is. I don't even think you can buy it. I think you can buy a few copies maybe on eBay or something. Someone emailed me the other day and said that they found one for like $1,000 on eBay, something foolish or I don't know, but I think they pulled it down. Will there be a time delay in the trial tomorrow? No, it will be live. When I say that, there may be a 10-second delay, but you will see it live, and I will be posting updates. If you can't watch and you want to read the written updates like I did during the trial, I'll be doing that as well. Has anyone heard from Kouri's boyfriend? Is he okay? And what about Carmen? Is she still okay? Nate, will you please interview them? I would love to interview them. I would love to talk to them off the record. I have tried to reach them. Eric Grossman, Josh he's hard to catch. If anyone has a connection, let me know. I'll talk to him off the record. I know many of you are concerned about if he's okay. Carmen, would love to talk with her too. And I know some of the questions too coming in tonight are what happened with her immunity deal, if that's been finalized. I don't know all the details on that. It may have taken up until the sentencing tomorrow for that to then get processed and pushed through. I know there was talk that she had moved to Vegas. I don't know if that's still true, but I would love to talk with them. I'd love to talk with Eric's siblings, of course, and his friends. I've reached out to many people. Some have said that we still have this other trial coming up. Kouri Richins has a bunch of other charges in the other trial that I talked about with Rachel. And so some of these people might be witnesses in that trial, and some of these people might just want to wait for that. Others might want to talk, and I'm fine. I can understand if people don't want to talk, but I would like to speak with them too. A while back, you ate at the same little cafe or deli that was where the infamous sandwich came from, the Mirror Lake Diner. What did you order there? It was so good. I think it was like the Turkey Club. And Jordan, my photographer, got the burger, and he said it was really good. They had good fries. We're going to try to go there while we're here. We're here all week, so I want to try to go back to the Mirror Lake Diner and talk with them. Does she have any good appellate issues? Well, I don't know if she does. Her attorneys will look for everything and try to include those in their filing, and we'll see when they issue their filing. Does anyone know if Lori Vallow's appeal has gone through? So her attorneys have filed the appeal, and then the state responded. It went back and forth, and now the Supreme Court of Idaho has agreed to hear her case, and that has not yet been scheduled, but it will be likely this fall, maybe, or in the spring, this year sometime, I believe. And that will be it's not like a normal trial. What will happen is the defense will get, I look like I'm hunching. I'll sit up straight. The defense will get 20 minutes and the prosecution will get 20 minutes. And then the Supreme Court of Idaho justices will ask some questions, and that'll be it. And then they'll issue their ruling whenever. They could issue it a week later or a month later or a year later. I don't think it'll be a year. Remind us what time the sentencing will be. It will be 9:30 tomorrow Mountain Time. That's 8:30 Pacific, 11:30 on the East Coast. And if you can't watch it live, you can watch it after the fact. Again, we'll have it on our YouTube channel. Will the sentencing memo be read in court tomorrow? I doubt it. I think that the sentencing will, the Bloodworth will reference it and then add to it. But and maybe say, we filed our memorandum, you can read it, and then that will be it. But maybe he'll read it. I don't know. Nate, we got a twinkle bed and we love it. How are you going to sleep in your hotel room without it? That's funny. That's from Dustin. I don't know. Probably not very well. The bed's over here. I purposely didn't shoot this to show you the bed. For those of you wondering, my wife and I have had issues for years. My wife has a vascular malformation in her back. She's divulged this publicly. I'm not speaking out of turn. And we actually, right before we got married, 2011, she had a little tiny bump on her back. And she went to the doctor and they said, oh, we'll cut it out. It's like a tumor or a cyst or something. Not cancerous. We'll go in and cut it out. So about a month before our wedding, she goes in. They go in. I was with her in the waiting room. She did the surgery, and the doctor comes out and says, I cannot take that out. If I take that out, she will bleed to death. He had cut into her, and it was a gnarly blood vascular malformation, like blood veins and arteries all tangled up. We're sent to Duke University. We were living in Richmond, and Erica ended up, sorry, this is a tangent. You're probably like, what does that have to do with anything? Erica ended up, she was so worried about her wedding dress because she had a huge gash, she still does, across all her back. Luckily it wasn't an issue with her dress, but she's like, great. It was swollen and yucky. And we ended up going to Duke, and they're like, here's how we'll treat it. We'll inject it with alcohol, and it will shrivel up slowly, and you'll come multiple times, and eventually it will shrink. So we go the first time. It's okay. We go the second time. During the procedure, they puncture her lung. She's awake during this. They've numbed her, but when she gets up, she's like, She couldn't breathe. She's like, I'm so far out of breath. They're like, oh, we wrapped the bandage around you so tight. That's why, just loosen it. We go home to our house in Richmond. The next day, she's like, I can't breathe. She's like, out of breath. Finally, she's like, we gotta go. I don't know what's wrong with me. We go to the ER, and they're like, you have a collapsed lung. She's admitted to the hospital. If you've had a collapsed lung, they had to cut right here and inflate it again. Hurt like crazy. She stayed in the hospital for 2 days, and she's like, I'm never getting that thing treated again. We did go back one other time to Duke. They were very apologetic. Anyway, fast forward, that was all 2011. She never went back. The vascular malformation has grown. We've been through 10 mattresses because it's so painful for her to sleep. And I like a really firm mattress. She likes the mattress more soft. And last year, a year ago, I wrote on my Facebook page how we were just having the worst time with our mattress. We bought one, a really expensive one, and got it, and it was awful. We tried it for 3 nights, and thank goodness we were able to return it. And the kind folks at Twinkle Beds here in Utah, where I am, family-owned business, made in America, Heidi reached out and said, we want you to try one of our beds, and if you don't like it, send it back. We work with chiropractors to make the bed work. So anyway, we went. I was driving home from Lori Vallow's Arizona trial. I went in. I lied down on the bed in the showroom. I'm like, we'll try it. It arrived a week later. Erica's like, this is amazing, and we've had the bed ever since, and it's worked. In fact, my parents just got one, and my mom, who's, I won't tell her age, she loves it. I love it. So it actually, I kid you not, am I getting old? Because when I go to hotels and sleep in their beds, I wake up with a sore back. I'm not getting paid by Twinkle to say any of this, but they are doing their Memorial Day sale. It starts this weekend. And if you order a mattress, you get all sorts of free stuff like sheets and pillows and blanket, all a sweet, like $600 package. You also get 30% off if you use the promo code Nate, Nate, NITE, NITE. They've been huge supporters of East Idaho News, of Courtroom Insider. They watch, so I'm happy to shout them out. You can go check out their website if you want and see if there's a mattress that you might like. And you get like a 90-day policy, I think, to try it out. Okay, other questions. Nate, when is Kouri's other trial? I don't know. It hasn't been scheduled yet that I know of. I think they were getting through this one. Will she have the same attorneys? Another good question. I don't know if the court is going to grant her 3 attorneys on this next one, as it's not like anywhere near a death penalty case. She'll probably be given 1. She could settle. I know many of you were asking, could she settle? And she very much well could. Let's see. Nate, will you be going live in the morning? We'll go live. I might go live on the way to the courthouse. Just stay tuned. It's bad reception over by the courthouse. It's like a cell phone hole. You can't get any signal, but if we can, I'll go live, and Jordan will be with me. And Nate, do you plan to do anything fun while you're in Park City? I plan to work. We got here this afternoon, and it was threw one thing after another. And I hope to do some interviews, like I said. So tomorrow night, we'll be here with Courtroom Insider again, reacting to the sentencing. I'll be giving you a recap like we have before. And then on what's tomorrow, Wednesday, Thursday, hopefully I'll have some fresh interviews for you with people connected to the case, along with Friday night. So plan to be here all night with me if you can. And then next week, have some fun stuff too. Many of you asked about Nick Edwards. He's the Daybell investigator who went on to lead the Internet Crimes Against Children Task Force in Idaho. He recently left his job. He didn't lose it. He resigned to start a new position, and he's going to come on here and talk about the Daybell case for the first time. He hasn't talked about it. He testified in it, and he's also written a book about his career. So that will be, I think, next Monday. So anyway, we got programming set for the next week. I apologize. I have this cap here that I'm playing with off to the side, and I'll stop doing that. Anyway, thanks again for being here again. Here's where you can find me: Facebook, X, Insta, YouTube. We went long tonight. I appreciate your patience. Tonight, we remember Kouri Richins. We think about him on the eve of his 44th birthday, all the good he did in the world when he was here, and all of the good he could be doing if he was still here. But hopefully tomorrow, each of us can think about him for a moment or two as the woman accused of murdering him learns her fate. And we hear from those who loved Kouri, and we hear the good things about him. Everybody, thank you so much for watching. I'm Nate Eaton. Have a good night. We'll see you tomorrow.